Welcome to EU Privacy for All, Session 5 on GDPR, about the Article 43a, basically dealing with foreign agencies' law enforcement requests. First of all, let's stress what's going on in Recital 91. When personal data moves across borders, then there is an additional risk that the ability of individuals to exercise data protection rights abroad would be compromised. This is the first observation in this recital. Supervisory authorities may also find that they are unable to pursue complaints or conduct investigations. This is a second observation. Consequently, it leads to a situation in which there would be insufficient preventative or remedial powers, inconsistent legal regimes, and practical obstacles like resource constraints. Basically, it leads to the final conclusion that there is a need to promote closer cooperation among data protection supervisory authorities to help them exchange information and carry out investigations with their international counterparts. As you can see, it summarizes the debate going on Safe Harbor today. European Parliament was the one proposing the draft of Article 43a. The first paragraph was mainly retained. The second, third, and fourth were dropped. They dealt with an obligation that the controller or the processor that is requested to provide data shall notify the supervisory authority of the request without undue delay and must obtain prior authorization. Then the authority should assess and inform. In the EU Council draft, Article 43a was totally deleted. Finally, this article, entitled Transfers or Disclosures Not Authorized by Union Law, has been maintained in the final draft. As you can see, it provides key requirements. A judgment of a court or tribunal, or the decision of an administrative authority from a third country, requiring a controller or a processor to transfer or disclose personal data, might be recognized or enforceable only if based on an international agreement. It could be, for instance, a mutual legal assistance treaty, an MLAT, but it could be another kind of agreement. In the directive currently, there is no such provision, and transfers or disclosure of data are framed in different articles, but not specifically foreign law enforcement requests. What should accountable data controllers or processors get prepared for? First, being ready to hand over a transparency report if asked to do so. Second, promote usage of international agreements. In Recital 90, some specifications could be interesting. Basically, the extraterritorial application of foreign laws, regulations, or other legislative instruments may be in breach of international law, impeding the attainment of the protection of individuals guaranteed in the Union by this regulation. Therefore, one key point to retain is the fact that transfers should only be allowed where the conditions of this regulation for a transfer to third countries are met. That is to say, Article 41 to 45. What is needed now, potentially, is a new MLAT. That is to say, an international agreement that would be a little bit more efficient.